بسم الله الرحمن الرحيم الحمد لله رب العالمين والعاقبة للمتقين والصلاة والسلام على رسوله الكريم أما بعد. Alhamdulillah, we've been studying Islamic inheritance. Up to this stage, we've covered all the necessary detail we had to cover in regards to inheritance from an Islamic perspective, the Islamic rules of inheritance. What do we do with the assets, with the estates of a person that's passed away? So we've learned that first we use it in a funeral cost, etc. The detail was given in the earlier chapters. Thereafter, after all the necessary costs are done, then we use the money for the debts. Thereafter, the remaining estates, up to a maximum of third, we can use it for any wasiyah, Islamic will that was made. And the other 2/3 will go to the inheritors, fixed by Sharia, fixed by Islam. And then how to distribute it, what portions to give, and all the detail, alhamdulillah, over the many chapters we've covered. So from an Islamic viewpoint, we've covered the rules of Islamic inheritance fully. However, it would be good at this stage, before we finish the overall course, it'll be good to understand to some level the inheritance laws within UK or any other modern country. Obviously, every country will have few nuances, few differences. So what we're about to study right now will be based on UK, and even that within UK, it can keep changing. So as mentioned here, it's the rules of UK as of 2024. Now, after 5, 10, 15 years, they may change, they may not change. But ultimately, it's the responsibility of each person to keep up to date with the inheritance laws or any major laws which may impact you within the country that you are living in. Because ultimately, we want all our inheritance to be distributed. In a perfect world, we want all our inheritance to be distributed according to the rules of our religion, according to the rules of Islam. So we need to be aware of inheritance laws in the UK enough that we know how to ensure we make sure our money and our assets are used and maximized in the Islamic way. Because, for example, in the UK, if I have assets over a certain threshold, those assets have the chance, great chance, of being taxed 40%. So that means a large portion of my assets could potentially be given to HMRC, to the government, to the tax person. Whereas from an Islamic viewpoint, the money should really be distributed amongst the inheritors, amongst the relatives. So what can I as an individual do to ensure my wealth is distributed according to Islamic law? So to understand that, inshallah, in the next session, we'll also talk about how to write an efficient will. But before we come on to writing an efficient will, again, it'll be very useful to ensure we know what the inheritance laws of the UK are. Because so that we know also what kind of will work, what kind of will not work in the English law. So few of the main rules for inheritance law within the UK. Again, this is not an exhaustive list. Not every single law of inheritance is covered. But some of the main rules. So inheritance tax, IHT, that's the tax applied to someone's estate. By the way, estate includes property, money, possessions. Basically, literally anything a deceased person leaves behind, that's his estate. So once you work out the value of the estate a deceased person has left behind, inheritance tax can apply to that. In fact, certain gifts that you might have made during your own lifetime to people, inheritance tax may even apply to those gifts that you gave away to someone. You gave a gift to someone, you've given away to someone, but there's possibility inheritance tax may apply to that. Because, for example, imagine someone just a week before he's about to pass away, he gives everything away, his house away, his estate, he tries to give everything away as a gift, just trying to avoid the tax. Then the law will come into play and say, no, whatever gift you've given away within a certain time frame, that will also be taxed. More detail regarding gifts or tax, inheritance tax on gifts is coming in one of the later points. So IHT is the inheritance tax. Now, before the inheritance tax is applied, or before all these details are applied, any deductions that are approved, that are true. For example, debts that you owed to people, or the funeral expenses, those can be excluded or deducted from the value of the estate. Very similar to Islamic law, that the debts you owe, funeral expenses are first paid off before you work out the total estates left. So similar in English law. The value of the estate before calculating the inheritance tax, etc. First you subtract the debts owed by the deceased or the funeral expenses. Next, the inheritance tax rate in the UK, IHT rate, is 40%. So once you reach above the threshold, the tax-free threshold, so in point number 5, the tax-free threshold is coming. So there's a certain amount you don't get taxed on, up to a certain amount. But after that amount, whatever wealth, estate you have, you'll get taxed 40%. In terms of deadline to make the payment must be made within 6 months of the death of the individual. If it's not paid, then it could be a late penalty for the late payment. So these are important rules that even family members, etc. of the deceased need to know as well. Now, number 5, what is the threshold? In the UK, what is the tax-free threshold? So if I have estates, all my estates, after I pass away, when the estates are added up together, if the estates are 300,000, will there be any inheritance tax on that? The answer is no. Because the NRB, the nil rate band, that's the threshold. That if your assets are below this threshold, there is no inheritance tax. In 2024, that threshold was 325,000. If you do a very quick Google search, it will tell you the updated figure of the no inheritance tax, basically the nil rate band, the NRB, for the threshold for which there's no inheritance tax to pay until that threshold. So with £300,000, I won't need to pay any. From my assets, no inheritance tax will be paid. So no inheritance tax. Again, at £325,000, no inheritance tax will be paid from mine. However, if it's £400,000, then the £400,000, the extra 75,000, not the first 325,000, but the extra 75,000 pounds, there's potentially tax on that. When I say potentially, there is more detail that sometimes even up to 500,000 it's forgiven, but above 325,000, now it depends on the detail. So there's potentially you will be taxed on the 75,000, 40% of the 75,000, and you can see 40% of 75,000. So you've just got a bit more than the threshold, 75,000. But now look how much tax 40% of that will be given away, which is £30,000. So if it was pounds, £30,000. So just think about it. £30,000 out of your assets is just going to go into tax. And obviously, as the assets increase, that was an example of 400,000. If your assets are £1 million, then anything above 325,000, so the 625,000 or so, or 675,000 pounds, 40% of that, loosely, that's like almost half of your wealth will be given in tax. So that's why it's important to know where your money will go from an English law perspective after you pass away. So £325,000 is the threshold for no inheritance tax. If a person has a residence, a property, then there's an extra allowance, but the allowance has certain conditions which are below. So if a person has residence as part of his estate, so as part of his estate, his clothes, his possessions, his house, etc. So as part of his estate, one of the estate includes the property. Well then, if the property is part of the estate, then he's got an extra allowance of 175,000. So that basically means up to 500,000 pounds. 500,000 pounds is tax free. As long as the extra 175,000 is only used in the property. I'll explain. Imagine a person has estates after he passes away he has estates worth 450,000. But his property, out of the estates, the property is only worth 100,000. So yes, we did learn that if a person has a property as part of his estates, then the threshold can go up to 500,000. But the extra 175,000 can only be used for property. So that means that up to 100,000 can be used for property because the property is worth 100,000. So 450,000 minus 100,000, that leaves the estate as still 350,000. So there's still 350,000 of the estate left. Now without the property, the threshold was 325,000 only. So the extra 25,000, in this 350,000, there's an extra 25,000. The extra 25,000 will be taxed 40% at inheritance tax. You can't say my total amount with a property is less than 500,000. No. The property is above 325,000 pounds. The amount can only be used for a property, not for other estates. That's that rule. The second condition of the RNRB, the residence nil rate band. It can only be used to reduce the inheritance tax on property, which I've explained. The third condition, the property must be closely inherited. Now, do you know this property? Yes, there's an extra allowance for the threshold, tax-free threshold for a property. But that's only if this property is inherited by close relatives. Close relatives means spouse, children, grandchildren, great-grandchildren. Nephews and nieces are not included. So if nephews and nieces are inheriting these properties, there are no close relatives, so nephews and nieces are now inheriting. Then in that case, that extra 175,000 pounds that was given as a tax-free threshold will not be applied. The next condition, final condition. The overall estate must be below 2 million. By the way, if you've got estates of that figure, you should definitely be consulting solicitors, professionals in this field. Obviously, I'm giving general advice, but if you want more specific and detailed and much more nuanced and safe, from a law perspective, safe advice, then definitely you need to talk to solicitors, etc., who are professionals in the field. The overall estate value must be below 2 million. If the value is above 2 million, then this 175,000 tax-free threshold allowance may not apply. That's the first 6 points that we want to consider in regards to UK law. Carrying on. The 7th rule, spousal exemption. So a spouse, whatever she inherits, or whatever he inherits, so if the wife passes away, whatever the husband inherits, or if the husband passes away, whatever the wife inherits, inheritance tax will not apply to any inheritance that the partner gets. So a spouse, civil partner. But it's very important to try to be legally married. Because if you're not legally married, there's a big chance the spousal exemption may not apply to you. You'll have to go through court and there might be a long-winded process. You might not even win that case. Therefore, it's always best to be legally married to avoid any conflict and any problems. So any inheritance given to the spouse, that will not be taxed. Similarly, any gift, wealth gifted to a spouse or civil partner prior to death, irrespective of how long before it was given, even if it's 1 week before, 1 month before, 1 year before, it will not be taxed. Next, number 8. If the spouse passes away but does not use their tax-free allowance at all or only partially uses it, whatever is remaining from their tax-free allowance, whether from the NRB or whether from the residence NRB, so whether the 325,000 or whether the 500,000, if the spouse, for example, the wife passed away, the wife never used any of the threshold, she never had any estates left on her, she never used any of the threshold. So in that case, 500,000 pounds from the wife can now be transferred over to the husband. So now the husband's tax-free threshold is the wife's 500,000 plus his 500,000. That can go up to 1 million. That can go up to 1 million potentially. Obviously, this depends on residence, on house, and all that. But there's potential that that exception can be passed over. So that's point number 8. Point number 9. Now, the next few points are regarding gifts. So we've already learned gifts given to a spouse don't have inheritance tax applied to them. Similarly, gifts given to a charity or any political gifts to political parties, etc., they don't have any tax as well, irrespective of how long before death they were made. So gifts given to spouse, given to charity, given to political parties, they are inheritance tax exempt. However, majority of the other gifts, other than the spouse, charities, or political parties, they have a 7-year rule. What that basically means, that if you just gave the gift literally within the last year, once you found out that you're end of life now, then you gave all these gifts away to avoid the inheritance tax. Well, the taxman will say that no, you just tried to avoid inheritance tax, we're not going to apply this gift. Or we're going to apply the 7-year rule on it. And the 7-year rule is what's mentioned in point 12, which is that if the gift was given less than 3 years from the point of death, then the full 40% on that gift will apply. The full 40% inheritance tax. If it was given more than 3 years, less than 4 years, since the time of the death of the deceased, so the deceased gave this gift 3.5 years ago, then 32% tax will apply on that gift. And likewise, if it's 6 to 7 years, then 8% will apply. If it's more than 7 years, then yes, no tax will apply on that gift. Then it will be assumed that fully got transferred to the other person. So that's basically point 10, 11, and 12 overall explained. As mentioned, to those that are non-exempt, gifts given to non-exempt individuals has the 7-year rule. However, gifts given to exempt individuals, for example, spouse, charities, political parties, they will not have the 7-year rule. Those gifts will not have any tax applied upon it at all. So that's the first 12 points. Now point number 13 and 14. Point number 13 and 14. Point number 13 says, it's always good, in fact you should make a valid will. Will that's valid within the country that you're living in, for example within UK. How can a person make a will which is valid according to UK? And the reason from an Islamic perspective why we also want to make a valid will is because if you don't make a will, point number 15 mentions, that's called you're in an intestate. So intestacy rules will come into play, and which we'll come to. But if you're intestate, you don't make a will, then your assets will be distributed exactly according to English law. You have little say in it. However, if you made a valid will, and in your will you write that distribute my assets according to Islamic law, and you make a valid will, which we will go through in the next session, inshallah, how to make a valid will within English law, then your wealth can be distributed according to the Islamic rules. Because the country, the UK law, allows a person to make a will such that it follows his religious rules. Generally. There is more detail in this, which we will explain when we go through the next session, where we explain how to make a valid will. So in the UK, it's important to make a valid will. But yes, to make sure it's a valid will, make sure it fulfills the conditions of a will according to UK law. Number one, or A, the person making the will, the testator, he must be of sound mind. So the person making the will, the person who eventually passes away, when he made the will, he must be of a sound mind. B, he must be 18 years of age or more. C, he must sign that will in the presence of two independent witnesses. Two independent witnesses, i.e. two other people. And it's always important that the people that are giving testimony there are not people that are beneficiaries or inheritors of the will, potential inheritors of the will, or people that are benefiting from the will, or spouses of people that are benefiting from the will. D, the two independent witnesses must also sign in the presence of the testator. And all of this must be done in one gathering. All of this must be done in one gathering. E, the testator can revoke earlier wills as long as they have the mental capacity to do so. The will that will count, every time they make a will, they make an update, they'll put a date. The will that will count is the last dated will. As long as the last dated will, all the conditions mentioned here are fulfilled. F, the testator must appoint an executor of the will. You have to appoint an executor of the will. And if it's for a trust, then you must appoint at least 2 executors for the will. And generally they say no more than 4 executors or trustees for the will. The executor has the legal authority to now execute the will according to the will, or according to, basically can manage the estate, according to the detail mentioned in the will. G, there must be no fraud, influence or coercion or force involved in creation of the will. If you force to make the will and other people can dispute that will and say, no, when this deceased made this will, he was forced to make the will, and they can challenge it in court and they win, then that will be disregarded. So it's important there's no fraud or under influence or force at the time a person is making a will. H, the will must be updated if the testator legally marries after making it. Once a person legally marries, any earlier wills are cancelled automatically. Therefore, after legal marriage, you must rewrite the will or update the will. I, the will must be the most recent one with all the conditions met. All earlier wills will automatically be cancelled. Now point 14, before we continue, point 14 just has a list of some of the famous acts which are important in inheritance law within the UK. So obviously these are detailed papers, there's a lot written in them, but generally if you go to a solicitor's, they'll have covered majority of the information in there and they'll know those rules and they'll advise accordingly. Moving on to number 15. Rule number 15, or point number 15 is, if a person passes away without a valid will, intestate. So the rules of intestacy will apply. And some of the main points of the rules of intestacy are mentioned below. I'm not going to go through every single point, but the outline is, and you'll get the understanding from A, B, C, which is if a person passes away without a valid will. Now English law, UK law will say, the spouse and the children, if there are any spouse or children alive, then they will inherit, nobody else will inherit. And even that, there's detail. How much will the spouse inherit? Well, up to 322,000 the spouse will inherit. Anything above that, the spouse will have half, the children will have the remaining half, which will be shared equally. So easy example. For example, if £400,000 estate is left by the deceased, and he has spouse and children arrive. So the first 322,000 will go to the spouse. The remaining money, which is 78,000. So the remaining money, which is 78,000. The 78,000 will be divided into two. Half is given to the spouse, and the other half will be for the children. They will equally share. So half of that 39,000 will be given to the spouse, and the other 39,000 will be shared amongst the children. So the spouse will get 322,000 plus the 39,000 in that example. Point B, if there is no spouse, then it'll go to the living descendants, children or grandchildren, etc. There's more detail. If there's no descendants as well, then it'll go to the parents. So if there's no descendants, then it goes to the parents. If there are no parents, then it goes to the siblings. And like that, the rules of intestacy laws continue. And it's best to make a will. If you've not made a will, then this is how English law or UK law will distribute the wealth. So now, alhamdulillah, we've finished the main rules that we wanted to cover. Now we'll go through some worked examples. Most of them are very straightforward. All the answers are here as well. So it's easy to understand. Just to make you understand some of the UK laws, ultimately, if you made a good Islamic will, which we will study in the next session, which is also sound legally in the country that you're living in, for example, in UK, then a lot of your wealth will generally be distributed according to the will. But scenarios where there is no will, or your assets are much beyond the threshold and you will be taxed now, then what's the way that the English law will work this out? So a person dies leaving 300,000, property valued 300,000, and other assets valued 190,000. So that's a total of 490,000. If you remember the RNRB threshold, that RNRB threshold was 500,000. So if it's 175,000 plus is used in a property, then you've got until 500,000 threshold tax-free allowance. So the estate is 490,000. Subtract the 175,000 because that goes to the property. That means you're only left with 315,000. 315,000 is less than the NRB, the tax-free threshold. The tax-free threshold is 325,000. 315,000 is less, so you will not be taxed. Very simple example. Another example. If a person dies leaving behind a property worth 100,000, other assets worth 390,000. So again, the same total figure of 490,000. However, in this case, the property is not worth that much. So yes, from 490,000, we'll subtract the 100,000 for the property from the R and RB. However, the remaining 390,000, that's above the threshold of NRB, which is 325,000 tax-free allowance. So come on, we'll subtract the tax-free allowance of 325,000. That still keeps 65,000 remaining. There will be 40% tax on the 60,000 remaining, which is £26,000. Tax will be due on this total estate of 490,000. A third example. A person dies, but he's made the following gifts in the last few years. 50,000 to a friend 9 years ago. Well, 7 years or more, gift was given 7 years or more ago, then that will be excluded from inheritance tax. So no tax. No tax. So he mentions it here underneath. A gift of 50,000 made 7 years ago is not subject to inheritance tax since it falls outside the 7-year period. 325,000 to a sister 4 years before the death. Now a gift given 4 years, a gift of 325,000 made 4 years ago would not be subject to inheritance tax if the nil rate band has not been exhausted. Because if it's 325,000 and the person's NRB has not been used already, we'll just say, okay, the 325,000 can just be assumed, subtracted, or made tax-free because of the NRB. However, if the 325,000, if the NRB has already been used up, then on the 325,000 pounds, there will be tax on that gift. But because it was 4 years ago, the tax amount, as mentioned above in the percentage, it will be 24%. So if it's 4 to 5 years, then 24%. 24% of the gift will basically be taxed, not 40%. And if 100,000 pounds was given to a friend 3 years before the death, again, if it can be used as part of the tax-free allowance of 325,000, then we'll use it. But if it doesn't fall within there, if the tax-free allowance has already been used, then this 100,000 given 3 years ago will be subject to IHT inheritance tax. And because it's 3 years ago, there will be 32% tax due. 32% tax due. Therefore, 32,000 for the 100,000, 32,000 pounds will be given in tax. Example 4. And this is the final example. A person dies and leaves behind the following: a property worth 200,000, other assets worth 250,000, a lifetime gift of 100,000 made 2 years ago. So what will happen here? So the total assets, including the gift, is 550,000. Because it was only 2 years ago, we need to now include the gift. Firstly, for the property, 175,000 from the R&B allowance can be subtracted. So now we're only left with 375,000. Now, from the total assets remaining, the NRB allowance can be subtracted. So now we're only left with 50,000. From the 50,000 we've been left with, because the gift was only made 2 years ago, so 50,000 is left. So notice, from the 100,000, 50,000 of that could be used in the allowances. But the other 50,000, unfortunately, we've used up all our allowance, tax-free allowance. So now the remaining 50,000 will be taxed. And how much tax will it be? Because it's only 2 years ago, we learnt above, gifts given 2 years ago will have the full 40% tax. So 40% of 50,000 will be taxed. Hence, 20,000 pounds will be given in tax. So alhamdulillah, we've covered overall rules of inheritance tax in UK, the UK law. But again, I want to stress that this is not some legal professional advice on UK law inheritance tax rules. This is just an idea, just to make you start thinking about the main rules of inheritance tax and how the rules are applied in UK law. Just to give you a brief overall understanding. Although many of the important rules have been covered, but if you have large assets, especially if you have large assets, definitely you need to consult a professional in the UK law, inheritance laws in the UK. You need to consult a professional in regards to that. Someone who studied that really well and with detail. But in any case, inshallah, it does give us a good understanding of how Islamic law and UK law, there are some similarities and also there are many differences that you can see as well. That will take us on to the next and final session, which will be that why it's so important to make an Islamic will which stands UK or English law. So inshallah, in the next session, we will be going through our final session, which is how to make a will, what are the conditions, what are the kind of information that you need to include, you must include in the will, or what are the kind of information which you may include in the will. Inshallah, in the following session, we will study that. Jazakallahu khairah. Assalamu alaikum wa rahmatullah. Subhanakallahumma wa bihamdika nashhadu an la ilaha illa anta nastaghfiruka wa natubu ilayk.